Hello everyone, welcome to MAYANK LAWHOLIC. In this video, we will solve the question paper of Delhi Judicial Service of Higher Judicial Services of 2019 and 20. 2019-20 paper we will discuss here. So let us start with the question number 1. Section 497 of Indian Penal Code was struck down by the Supreme Court in which of the following judgments? Options are Joseph Sine versus Union of India AIR 2018. Option second, Navtej Singh Johar versus Union of India 2018. Option C, Saumitri Vishnu versus Union of India AIR 1985. Option 4, V Revati versus Union of India. What will be the correct answer? Correct answer is option 1, Joseph Sine versus Union of India. Joseph Sine versus Union of India was related to section 497 of IPC. Section 497 IPC, also commonly known as adultery. Now let us see the question number 2. When a complaint is filed, the relevant data for computing the period of limitation under section 468 of Code of Criminal Procedure 1973 is the option 1, date of filing of complaint, option 2, date of taking cognizance, option 3, date of framing of charges, and option 4, both second and third option. What will be the correct answer? Correct answer is option 2, date of taking of cognizance. Section 468 of CRPC comes in chapter 36 of CRPC. Section 468 talks about the bar to taking cognizance after lapse of the period of limitation. Here correct answer is 2, date of taking cognizance. Question number 3. In which of the following decisions Supreme Court held that informant and investigation officer cannot be the same person? Options are option 1, Mohanlal versus State of Punjab, option 2, P. Chidambaram versus Directorate of Enforcement, option 3, Yashwant Sinha versus CBI, and option 4, D.K. Basu versus State of West Bengal. Correct answer is option 1, Mohanlal versus State of Punjab 2018. Informant and investigation officer can't be the same person. This is held in Mohanlal versus State of Punjab. Question number 4. In an appeal, court has the power to direct concurrent running of A. Substantive sentences for different offences, B. Default sentence in lieu of fine for different offences. Option 1, both A and B are correct. Option 2, only A is correct. Option 3, only B. Option 4, neither A nor B. Here the correct answer is option 2, only A. That is substantive sentences for different offences. As per Criminal Law Amendment Act 2018, the presence of informant or any person authorized by him shall be obligatory at the time of hearing of bail application in respect of offences under which of the following sections of Indian Penal Code? Option 1, section 354, 354B, 354C. Option 2, section 376(3), section 376AB, section 376DA, and section 376DB. Option 3, section 376A, 376B, and 376C. And option 4, both 1 and 3. Here the correct answer is option 2, section 376 clause 3, section 376AB, section 376DA, and section 376DB. Section 376 clause 3 talks about the punishment of rape under 16 years of age. Section 376AB talks about punishment of rape under 12 years of age, and section 376DA talks about punishment of gang rape under 16 years of age, and section 376DB talks about punishment for gang rape of women under 12 years of age. As you all are aware, section 375 is rape and section 376 is punishment for rape. Now let us proceed to question number 6. In age determination inquiry under section 94 of Juvenile Justice Care and Protection Act 2015, which of the following will have the precedence over other? Option 1, a birth certificate given by the corporation. Option 2, a date of birth certificate given by the school/matriculation or equivalent certificate. Option 3, ossification test or any other latest medical age determination test. Option 4, all of the above. Here the correct answer is option 2, a date of birth certificate given by school matriculation or equivalent certificate under section 94 of Juvenile Justice Care and Protection Act 2015. Now let us see the question number 7. A juvenile in conflict with the law is tried for an offence which is punishable with maximum sentences of not more than 7 years, but there is no minimum sentence. The offence will be tried as A. Petty offences, 2nd, serious offence, 3, heinous offence, and 4, none of the above. Here the correct answer is serious offence. Question number 8. Age determination inquiry in terms of Rule 12 of Juvenile Justice Care and Protection of Children Rule 2007 is applicable to option 1, juvenile in conflict with law, option 2, child, option 3, child victim, and option 4, all of the above. Here the correct answer is all of the above. Age determination inquiry in terms of Rule 12 of Juvenile Justice Care and Protection of Rules 2007 is applicable in juvenile in conflict with law, child, child victim, all of the above. Now let us see the question number 9. A foreigner who has habitual residence in India wishes to adopt a child from India. The requirement for obtaining no objection certificate (NOC) from the diplomatic mission in India of his country in view of the section 59 clause 12 of Juvenile Justice Care and Protection of Children Act 2015. Option 1 can be waived by the concerned diplomatic mission. Second is mandatory. Third is directory. 4 is not required. Here the correct answer is mandatory. It cannot be waived, is not directory, and is not required. The correct answer it is mandatory, given under section 59 clause 12 of Juvenile Justice Care and Protection of Children Act 2015. Section 59 talks about the procedure for inter-country adoption of an orphan or abandoned or surrendered children. Okay. Now let us see the question number 10. Under Juvenile Justice Care and Protection Act 2015, the child under section 2 clause 12 means a person who has not completed the 18 years of age, a boy or a girl who has not attained the age of 21 years, a boy who has not attained the age of 21 years, and a girl who has not attained the age of 20 years, or none of the above. Correct answer is option 1, who has not completed the age of 18 years, below 18 years. This we have also discussed in the definition of child in POSCO Act. Question number 11. A child in conflict with law who is between the age of 16 years to 18 years and is convicted of committing a heinous offence is to be kept as per section 49 of the Juvenile Justice Care and Protection Act 2015 in an first observation home, second children home, third place of safety, and 4 special home. The correct answer is place of safety. It is given in section 49, place of safety. A child in conflict with law who is between the age of 16 to 18 years. The answer is place of safety. Now let us see the question number 12. A court may dispense with the examination of accused under section 313 subsection 1 clause B of the Code of Criminal Procedure 1973 in a first dowry death case, second summon case where his personal attendance is dispensed with, third case of culpable homicide, fourth case of kidnapping and abduction. Correct answer is dowry death case is also wrong. Correct answer is second, summon case where his personal attendance is dispensed with. Question number 13. The salient feature required to be considered to assess the defense of grave provocation within the meaning of IPC is option 1, can only be by words spoken and not otherwise. Option 2, the mental background created by previous act of the victim cannot be seen, considered in any circumstance. Whether a reasonable man belonging to same class of society as the accused placed in same situation would be provoked to lose his self-control need to be considered. Option 4, applicable only if accused has a scope of premeditation and calculation. Correct answer is option 3, whether a reasonable man belonging to the same class of society as the accused. Reasonable man जो कि accused की society से belong करता है, इस particular situation में would be provoked to lose his self control need to be considered. ये आंसर सही है और आप सभी को पता है कि IPC में grave and sudden provocation के लिए बड़ा ही फेमस केस है KM नानावती, आप उसका भी जजमेंट पढ़ें. The word person under section 11 of IPC denotes, बहुत easy question है. Option 1, only male human being. Option 2 includes a company or association or a body of person whether incorporated or not. Option 3 only female human being, and option D only government companies. Government companies नहीं हो सकता. Female human being खाली person में आएगा, ये भी नहीं हो सकता. Male human being आएगा, जब female नहीं आ रहा तो male कैसे आ सकता है, तो ये बाकी सारे ऑप्शन गलत हैं. ऑप्शन 2 सही है, includes a company or association or a body of persons whether incorporated or not. Now let us see the question number 15. The presumption under section 113B of Indian Evidence Act 1872. 1. Can be raised only if essential ingredients of section 300B IPC are proved. Is not rebuttable. Is always to be raised in death cases of a married woman if she dies even for normal medical reason within 7 years of her age. None of the above. आपको पता है सेक्शन 113B बहुत इंपॉर्टेंट सेक्शन इंडियन एविडेंस का, जो कि बात करता है प्रिजम्पशन ऑफ डाउरी डेथ. तो आंसर है पहला सही, इसमें फर्स्ट ऑप्शन सही है. कैन बी रेज्ड ओनली इफ एसेंशियल इंग्रेडिएंट्स ऑफ सेक्शन 304B ऑफ IPC आर प्रूव्ड. Now let us see the question number 16. A salient feature of plea bargaining. Option 1 is the statement of fact stated by the accused in his application for plea bargaining can be used against the accused for any other purposes. Option 2 is the judgment delivered by a court in case of plea bargaining is not final and can be challenged in appeal. Option 3 is applicable in respect of offences punishable with imprisonment up to a period of 7 years. Option 4 applies to offence committed against a woman or a child below the age of 14 years. Correct answer is option 3. This is unrelated to plea bargaining. This is the correct answer. Is applicable in respect of offences punishable with imprisonment up to a period of 7 years. Question number 17. Which of the following is correct for an inquest report under the Code of Criminal Procedure 1973? Option 1 cannot be used under section 145 of Indian Evidence Act for cross-examination. Option 2, it is a report of an expert. Option 3, it is not a substantive evidence. Option 4, in case of omission of an inquiry will be fatal to prosecution case. The correct answer for this question, option 17, is option 3, is not a substantive evidence. In question number 18, which one of the following is correct for an inquiry under section 2 clause G of CRPC? Option 1, it is trial under the court by magistrate or court. Option 2, it is other than the trial under the court by a magistrate or a court. Option 3, it always relates to an offence and not otherwise. Option 4, it always culminates in conviction or acquittal. The correct answer is option 2, it is other than the trial under the court by a magistrate or a court. Inquiry is given under section 2G of CRPC. Definition of inquiry means every inquiry other than a trial conducted under this code by a magistrate or a court. So this is the right answer. Question 19. The provisions of the Payments of Gratuity Act 1972 are applicable to 1. Regular employees, 2. Casual employees, 3. Temporary employees, 4. All of the above. Correct answer is 4. All of the above in regular, casual and temporary employees. Question number 20. Under the provision of the Payment of Gratuity Act 1972, gratuity payable to an employee cannot be forfeited. 1. In a case where disorderly or violent act is committed by an employee. 2. In a case where employee commits an offence involving moral turpitude. 3. In a case where the employment is terminated on account of any act, willful omission or negligence on his part and the same cause damage or loss to the employer. 4. In a case where the employee is discharged on account of his or her service not being found up to the mark. The correct answer for this is option number 4. In a case where the employee is discharged on account of his or her service not being found up to the mark. Now let us see the question number 21. The term wages for the purpose of the Payment of Gratuity Act 1972 includes durance allowance, house rent allowance, bonus or overtime allowance. Correct answer is 1. Durance allowance. DA. Question number 22. An order passed by the appropriate government granting or refusing to grant permission for closure of an establishment under section 25O of the Industrial Dispute Act 1947 remain in force for the period of option 1 6 months, option 2 1 year, option 3 2 year and option 4 3 months. Correct answer is option 2, that is 1 year. Question number 23. Wages as defined under the Industrial Disputes Act 1947 does not include option 1 value of housing accommodation, option 2 value of free electricity supply, option 3 travelling concession and option 4 gratuity. Correct answer is here is gratuity. What is the minimum time for which a workman must wait after approaching the conciliation officer before raising an individual direct industrial dispute under the Industrial Disputes Act 1947? Options are 30 days, second 45 days, third 15 days and fourth 60 days. Correct answer is option number 2, 45 days. Now let us see the question number 25. As per the Employees Pension Scheme 1995, the central government is required to contribute to the Employees Pension Fund at which of the following rates? Option 1, 50% of the contribution payable by the employer under the Employees Provident Fund and Miscellaneous Provision Act 1952, 8.33 of the employees' pay of every member of the Employees Pension Scheme. Option 3, 1.16% of employees' pay of every member of the Employees Pension Scheme. And option 4, none of the above. Correct answer here is option 3, 1.16% of the employees' pay of every member of the Employees Pension Scheme. Now let us see the question number 26. Which of the following documents would need to be compulsorily proved by an attesting witness regardless of whether its execution has been denied? Option 1, A registered general power of attorney. Option 2, a registrable sale deed. Option 3, a registered will. Option 4, all of the above. Correct answer here is option 3, a registered will. Now let us see the question number 27. Under which of the following circumstances will the evidence given by a witness in a judicial proceeding be relevant in subsequent proceeding under section 33 of the Indian Evidence Act 1872? Option 1, when the witness cannot be found. Option 2, when the presence of the witness cannot be obtained without undue delay or reasonable expense. And option 3, when the witness is dead. Option 4, all of the above. Here the correct answer is 4, all of the above. Under section 33 of Evidence Act, relevancy of certain evidence for proving in subsequent proceeding of truths or facts therein are stated. So all the options are here are correct. Now let us see the question number 8. X sues Y for rupees 1 lakh and relies on entries in his account books showing Y to be indebted to him in this amount. To prove the debt, option 1, the mere entries are sufficient. The entries are not admissible and independent evidence has to be adduced. Option 3, the entries are relevant but are not alone sufficient to establish the liability of Y. Option 4, the entries cannot be relied upon. Here the correct answer is option 3. The entries are relevant but are not alone sufficient to establish the liability of Y. Now let us see the question number 29. Any party to a suit may show that any judgment, decree or order which is relevant for a dispute under section 40, 41 and 42 of Indian Evidence Act 1872 which has been proved by the adverse party is option 1, delivered by a court not competent to deliver it. Option 2, in a suit or proceeding to which it was not a party. Option 3, a result of gross negligence. Option 4, state that is more than 12 years old. Here the correct answer is option 1, delivered by a court not competent to deliver it. The Indian representative who addressed the Parliament of World Religions in Chicago in 1893. This is a very easy question. Correct answer is Swami Vivekananda. Eliud Kipchoge is option 1, a Kenyan long distance runner, a member of US national soccer team associated with the civil war in Somalia and leader of African National Congress. Eliud Kipchoge is an athlete and he is a Kenyan long distance runner. Question number 32. The Boer Wars was fought between option 1, the British and South African states. Option 2, the British and the French led by Napoleon. Option 3, the Duke of Normandy and the British. And option 4, Egypt and Israel. Correct answer is the British and the South African states. The word war in African means farmer. There are basically two Boer Wars that are fought between the period of 1880 to 1902 among South Africa and South African states and British state. There are two Boer Wars fought. In first war, the British lost, and in second war, British won the Boer War, and the South African states became the colony of British. The duration of Boer War, Mahatma Gandhi formed the organization Indian Ambulance Corps. It is also one of the important information regarding to this question. Question number 33. The book The Motorcycle Diaries is an account for the life of. This is also a very easy question. The Motorcycle Diaries is an account of the life of Che Guevara. Now question number 34. International IP Index released by the US Chamber of Commerce measures. Here the correct answer is intellectual property environment. IP Index is related to intellectual property environment and it is released by the US Chamber of Commerce measures. Now let us see the question number 35. In which country are the Q members of Gaganyaan being trained? Options are USA, Russia, India, Japan. So this mission is of India, Gaganyaan. Answer is Russia, because in Russia, four Indian astronauts are getting trained for the mission Gaganyaan. Question number 36. The BIMSTEC member states are. It is also very easy question. BIMSTEC member states are Bangladesh, India, Myanmar, Sri Lanka, Thailand, Nepal and Bhutan. Option number 1 itself is the correct answer. Number 37 related to the current affairs question which might not be relevant in other examination. In December 2019, a 34 years old politician became the Prime Minister of Finland. Prime Minister of Finland, a 34-year was a lady Prime Minister of Finland. Her name is option number 3, Sanna Marin. India's first Lokpal is, this is a very important question of GK. India's first Lokpal is Justice PC Ghosh. Question number 39. The first case in which Supreme Court was called to determine how far the Constitution had secured personal liberty to the citizens of India was. Options are Kesav Nanda Bharti vs. State of Kerala, AIR 1973. Option 2, A.K. Gopalan vs. State of Madras, AIR 1950. Option 3, Indre Beriberi Union, AIR 1960. Option 4, Golaknath vs. State of Punjab, AIR 1967. The first case in which the Supreme Court was called to determine how far the Constitution had secured personal liberty to the citizens of India was, correct answer here is option number 2, A.K. Gopalan vs. State of Madras, AIR 1950. This is the correct answer and this was the first case. Community-based caste-based reservation in medical engineering colleges was held to be void by the Supreme Court in which of the following cases? Option 1, Menaka Gandhi vs. Union of India. Option 2, I.C. Golaknath and others vs. State of Punjab. Option C, State of Madras vs. Champakkam Dorajan. And option 4, none of the above. Here the correct answer is option number 3, State of Madras vs. Champak Dorajan, AIR 1951. Question number 41. Which judgment held that right to privacy is protected as an intrinsic part of the right to life and personal liberty under Article 21 and as a part of the freedom guaranteed by Part 3 of the Constitution? This is a very recent case and also very important case. Well, let us first see the options. Option 1 is ADM Jabalpur vs. Shukla, AIR 1976. Option 2, Indira Gandhi vs. Raj Narayan. Option 3, Indira Sahni vs. Union of India and others. But the correct answer is Justice K.S. Puttaswamy retired vs. Union of India and others, AIR 2017. This case is related to right to privacy which is protected under Article 21. Question number 42. In which of the following judgment the practice of talaq-e-biddat was set aside? This is also very important, a landmark case which has been asked in this question. Correct answer is, as you all know, Shaira Banu versus Union of India. In this case, the practice of talaq-e-biddat was set aside. Question number 43. In a suit for recovery of money, where it is established that money has been received by the defendant in an account maintained in a branch located within the territorial jurisdiction of the court, men within the said jurisdiction. Option 1, a part of the cause of action has arisen, an entire cause of action has arisen. Option 3, no part of the cause of action has arisen there. And option 4, no cause of action does not arise there, but if the parties agree to the cause of action shall be deemed to have arisen. Here the correct answer is option 1, a part of cause of action has arisen related to territorial jurisdiction of the court. Now let us see the question number 44. Rejection of a plaint is challengeable under section 96 of CPC. Option 2, not challengeable and only a fresh suit can be filed. Challengeable under section 115 CPC and challengeable under section 102 CPC. Correct answer is very easy. Rejection of plaint is challengeable under section 96 of CPC. Question number 45. Under order 21 rule 37 CPC, before arrest and detention, it is mandatory to issue show cause notice in the absolute discretion of the court whether to issue show cause notice or not. Option 3, no show cause notice is required to be issued under any circumstances. Option 4, mandatory for the executing court to issue show cause notice only if the execution is applied after 2 years of decree. Option number 4 is wrong and option number 3 is also wrong. Correct answer here is option number 1. Under order 21 rule 37 of CPC, before arrest and detention, it is mandatory to issue show cause notice. Question number 46. A construction contract is entered into between contractor X and a road building corporation. The contract specifically bars grant of any interest to the contractor for delayed payments due to disputes and in any respect whatsoever. The arbitrator, option 1, has the discretion to award interest under section 31 clause 7 of the Arbitration and Conciliation Act 1996. Option 2, cannot award any interest due to delayed payments. Or option 3, cannot grant interest only qua delayed payments but can grant interest on damages. And option 4, can grant interest as the clause is contrary to the public policy and void. Here the correct answer is cannot award any interest due to delayed payments. Now let us see the question number 47. Under the Arbitration and Conciliation Act 1996, award option 1 has to always state reasons up to which it is based, has to state reasons save when the parties have agreed that no reasons are to be given, has to state reasons save when the award is on agreed terms. So the option 4 is option 2nd and 3rd. So as you know, under the Arbitration Act, the options 2nd and 3rd are correct. Has to state the reasons save when the parties have agreed that no reasons are to be given, has to state reasons save when award is on agreed terms. So option number 2nd and option number 3rd is correct. Question number 48. A client X says to Y, an attorney, that he wishes to obtain possession of a property by the use of a forged deed on which he requests the attorney to sue. This communication is protected from disclosure in view of attorney-client privilege under all circumstances. This seems to be inaccurate because there is a forged deed that is coming into the picture. So this option is definitely inaccurate. Option 2, not protected from disclosure as attorney-client privilege does not extend to the communication furtherance of a criminal purpose. This answer is right answer. Now, but let us see all the other options also. Protected from disclosure in view of attorney-client privilege irrespective of the nature of proceedings, whether civil or criminal. No, this is inaccurate. Protected from disclosure in view of attorney-client privilege only in civil proceedings. This also is inaccurate. Correct answer is option 2, not protected from disclosure as attorney-client privilege does not extend. Here, because they are talking about the forged deed, does not extend to communication furtherance of a criminal purpose. Question number 49. The period of limitation for a suit by a principal against his agent for movable property received by the latter and not accounted for is option 1, 3 years from the date when the account during the continuation of agency is demanded and refused. Option number 2, 3 years from the date when the agency terminates if no earlier demand is made. Option number 3, 3 years from the date when the movable property in question was delivered by the agent. And option 4, both 1 and 2. Here the correct answer is option 4, both 1 and 2. That is option number 1, 3 years from the date when the account during the continuation of agency is demanded and refused. And option second, 3 years from the date when the agency terminates if no earlier demand is made. The concept of dynamic injunction was held by the Delhi High Court in UTV Software Communication Limited and others versus 1337 XTO and others was first propounded by option A, UPC Telkabel versus Constantin Film, European Court of Justice; GEMA versus Deutsche Telekom, Germany's Federal Constitutional Court; option 3, Roadshow Films versus Telstra Corporation Limited, Australian Federal Court; and option 4, Disney Enterprises versus ML Limited, High Court of Singapore. Here the correct answer is option number 4, Disney Enterprise versus ML High Court of Singapore Limited. This is a repeated question. This question has also been asked in various examinations. Under section 21 of the Arbitration and Conciliation Act 1996, the commencement of arbitral proceedings take place. Option 1, on the date on which a request for that dispute to be referred to arbitration received by the respondent. Option 2, when the court appoints the arbitrator. And option 3, when the petition under section 11 is filed. And option 4, when the notice invoking the arbitrator clause is issued. In this question, correct answer is option 1, on the date on which a request for that dispute to be referred to arbitration is received by the respondent. Question number 52. Under section 34 clause 3, Arbitration and Conciliation Act 1996, limitation period would commence from the option 1, date on which a signed copy of award was delivered to a party making application to set it. Option 2, date of award. Option 3, date of delivery of a signed copy of award to either of the parties. And option 4, date of stamping of the decree in terms of award. It's very easy. Option 1 is the correct answer. Date on which the signed copy of award is delivered to party making application to set it. Question number 53, grant of probate of a will. Option 1 is exclusive jurisdiction of probate court, is arbitrable, can be in a civil suit, and option 4, all of the above. Correct answer here is option number 1, grant of probate will is the exclusive jurisdiction of the probate court. Probate basically is a method through which a will is certified under the seal of court. Okay. Question number 54. A decision rendered in a proceeding again under section 372 Indian Succession Act 1925. Option 1 is a summary in nature. Option 2, does not finally decide the rights of the parties. Option 3, does not bar the trial of the same question in any other proceedings between the same parties. And option 4, all of the above. Here the correct answer is option 4, all of the above. Section 372 of Indian Succession Act 1925 talks about application for certificate. Now we will see the question number 55. Question number 55 is, X would be said to have died intestate in the following situations. 1. X, who left a will whereby he has appointed Y his executor, but the will contains no other provision. Option 2. X has bequeathed his whole property for an illegal purpose. Option 3. X has bequeathed 1000 rupees to Y and 1000 rupees to the eldest son of Z and has made no other bequest and has died leaving the sum of 2000 rupees and no other property. Z died before X without having ever had a son. X died intestate in respect of the distribution of 1000 rupees. And option 4, all of the above. In question number 55, the correct answer is all of the above. Mr. Sharma dies intestate. He leaves behind his wife, a son and a daughter. In order to be able to administer and manage the movable and immovable property left by him, the son can file A, a probate petition, B, petition for a letter of administration, 3, an application for succession certificate, 4, petition under section 92 CPC. The correct answer is petition for a letter of administration. When a person dies intestate or doesn't nominate an execution under the will, it is the letter of administration acts as a facilitating document. Letter of administration is granted to the beneficiaries after they apply to a court of law having competent jurisdiction. One more thing, letter of administration entitles administrator to all the rights belonging to the intestate as effectually as if the administrator had been granted at the moment after his death. Now we will move to question number 57. A grant of probate of a will. Option 1 constitutes the grantee, the sole heir of the deceased and the owner of estate bequeath. Constitutes the grantee the sole heir of the deceased but not the owner of the estate bequeath. Option 3 only declares the documents to be validly executed last will of the deceased. Option 4 only interprets the documents claimed to be the will of the deceased. Here a grant of probate of will, option 3 is the right answer, only declares the documents to be validly executed last will of the deceased. Now question number 58. The deceased L, a Hindu, married again during the subsistence of the first marriage. The first marriage was legal. The second wife bore him a daughter M. The court found the marriage to the second wife was not valid under the Hindu Marriage Act. What is the nature of M qua the state of L? Here the correct answer is, now let us first see the options. M shall be entitled to only become a coparsoner in the coparsonery of which L was a member and to claim petition thereof. M can inherit L's asset as an illegitimate child. Depends upon the discretion of the court. M will not inherit any part of the estate of the deceased. Here the correct answer will be the answer second. M can inherit L's estate as an illegitimate child because their marriage was not the valid marriage. So the option second is the correct answer. Now let us see the question number 59. The self-acquired property of a Hindu married female dying intestate whose husband predeceases her and who did not have any children devolves upon the following. Options are on her parental heirs, second on her husband heirs, third on her maternal heirs, and fourth depend upon the discretion of the court. In this question, correct answer is on her husband heirs. Question number 60. Inherited property of a Hindu widow who dies intestate and had a son and daughter shall devolve upon son, daughter. Son and daughter depends on the discretion of the court. Here the correct answer is son and daughter. Question number 61. The Hindu Succession Act 1956 applies to the person of all the following religion: Hindu, Sikhs and Parsis. Second option Hindu, Jains, Buddhists and Sikhs. Third option only Hindus, and fourth option Hindu, Jains, Buddhists, Sikhs and Jews. In question number 61, correct answer is Hindu, Jain, Buddhist and Sikhs. The Hindu Succession Act does not apply to Jews. That's why this is not the right answer. And here on Parsis also, Hindu Succession Act does not apply. So this is also not the right answer. But it applies to Hindus, Jains, Buddhists and Sikhs. So the correct answer is option 2, Hindus, Jains, Buddhists and Sikh. Which of the following statement is true? Statement 1. A general authority to transact business and to receive and discharge debts is sufficient to empower the agent to bind a principal by endorsing bills of exchange. Option 2. A minor may draw, endorse, deliver and negotiate notes, bills and checks so as to bind all the parties except himself. Option 3. When a day on which a promissory note or a bill of exchange is at maturity is a public holiday, the instrument shall be deemed to be due on the next succeeding business day. Option 3. An instrument which may be construed either as a promissory note or a bill of exchange is called a inchoate instrument and is invalid. In all the statements, the statement 2 is the correct statement. A minor may draw, endorse, deliver and negotiate notes, bills of exchange so as to bind all the parties except himself. Let us see the question number 64. When a contract creating partnership is rescinded on the ground of fraud or misrepresentation of any of the parties thereto, the party entitled to rescind his inter alia entitled in law to a lien over the entire assets of the firm forthwith towards any capital contributed by him. Option second, a right to be indemnified by the partners guilty of the fraud against all the debts of the firm. Option 3, premium for his share. The option 4, the goodwill of the firm preferentially. Correct answer is option 2, a right to be indemnified by the partners guilty of a fraud against all the debts of the firm. Now let us see the question number 65. Which of the following rules shall be observed in settling the accounts of a partnership firm after dissolution, subject to the agreement by the partners? Losses including deficiencies of capital shall be paid first out of profits, next out of capital, and lastly it is necessary by the partners individually in the proportion in which they were entitled to share profits. Option B. The assets of the firm including any sums contributed by the partners to make up deficiencies of capital shall be utilized in paying the debts of the firm to the third parties. Option C. The assets of the firm including any sums contributed by the partners to make up deficiencies of capital shall be applied in paying to each partner ratably which is due to him from the firm of advances as distinguished from the capital. Option D. The assets of the firm including any sums contributed by the partners to make up deficiencies of capital shall be applied in paying to each partner ratably which is due to him on the account of capital. Options are A and B above, A and C above, A and D above. Option 4, all of the above. So option 4 is the correct answer because all these statements are the correct statement. Now let us see the question number 66. A person who is a minor can be admitted to the benefits of a partnership if his share is liable for the acts of the firm. He can elect on attaining majority to continue as a partner by issuing public notice. He can be made personally liable. He may not sue the partners for the payment of his shares save when serving his connections with the firm. Which of the following is the correct answer? Here, In this question, the answer third is correct, first, second and fourth. Option 3 is not correct. He cannot be made personally liable. Here it is written he can be made personally liable. Okay, now let us see the question number 67. When any borrower defaults in the repayment of the secured debt or any installment thereof, the secured creditor may, within the meaning of section 2 of the Securitization and Reconstruction of the Financial Assets and Enforcement of Security Interest Act 2002. Option 1. Without notice to the borrower to discharge his full liability, taking possession of the secured assets within 30 days of the default by filing application before the Chief Metropolitan Magistrate or District Magistrate, after requiring the borrower to discharge full liability, obtain order of attachment before judgment to the secured assets from DRT. Option 3. Issue a notice to the borrower calling upon him to discharge full liabilities within 60 days, considering the representation or objections, if any, raised by the borrower. Communicate reasons to the borrower, taking possession of the secured assets of the borrower, take over the management of the business of the borrower. And option 4, immediately take over the management of the business of the borrower for the realize the secured debt. In this question, the correct answer is option 3. When any borrower defaults the repayment of a secured debt or installment thereof, the secured creditor may, within the meaning of section 2 of the Securitization, Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, issue a notice to a borrower calling upon him to discharge full liabilities within 60 days, considering the representation of objections, if any, raised by the borrower. Communicate reasons to the borrower and taking possession of the secured assets of the borrower and take over the management of the business of the borrower. So the option 3 is the right answer. Now let us see the question number 68. The secured creditor may, option 1, before exercising his options under Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, seek recovery from guarantors, file an application to the DRT or a competent court for the recovery of the balance amount of the secured debt not fully satisfied by the sale of the secured assets. Which of the above statement is correct? Options are both the above, none of the above, only one, and only second. Here the correct answer in this question is both the above. Both the options relating to secured creditor are correct in this question. Now let us see the question number 69. In the light of section 6 of the Specific Relief Act 1963, which of the following statement is true? Statement first, any person who is dispossessed without his consent of immovable property otherwise other than in due course of law may, by suit instituted within 6 months from the date of dispossession, recover possession thereof. Option second, no suit under this section shall be brought against the government. Here the options are only one is correct, only second is correct, neither of them is correct, and both first and second are correct. In question number 69, the correct answer is option 4. Both first and second are correct. Section 6 of the Specific Relief Act talks about suit by a person dispossessed of immovable property, and both the options are correct here. Now let us see the question number 70. A entered into a contract with B regarding the construction of a classroom at IHI Institute, Hyderabad. According to the agreement, the contract was to be completed within 9 months of the contract. However, B could not complete the contract within the stipulated time and demanded an extension of another 9 months. Finally, the extension was granted and the contract was completed after 18 months. A clause in this contract provided that in case of any failure or delay in the completion of the contract, the said failure or delay shall not vitiate the contract nor entitle the contractor to damages or compensation thereof. It was agreed that only a reasonable extension may be granted for the completion of the contract. A dispute arose between the parties which was referred to arbitration, wherein B demanded compensation or damages. In the light of the above mentioned facts, which of the following is true? So options are: the contractor is entitled to damage or compensation. The contractor shall not be entitled to damages compensation. The contractor shall not be entitled to damages or compensation because the contract only provides for reasonable extension time and no compensation in case of any delay or failure in the completion of the contract. The contractor shall not be entitled to damages compensation because the right to damages cannot be restricted despite absence of a clause for a monetary relief in the contract. So in this question, the statements 1 and 2 are not to be considered. Option 3 and 4 are elaborately discussed, but option 4 should not be considered in this question because it does not specify the correct answer. Option 3 is the correct answer because it was written in the contract that of the reasonable delay. So the third statement, the contractor shall not be entitled to damages compensation because the contract only provides for a reasonable extension of time and no compensation in case of any delay or failure in the completion of the contract. So this is the right answer. Now let us see the question number 71. Ravi, a trader at Chennai, by letter directs T to sell him some goods lying in a warehouse in Mumbai, and afterwards by letter revokes his authority to sell and directs T to send the goods to him Chennai. After receiving the second letter, enters into a contract with S, who already had information about the first letter sent by R, but not of the second letter for the sale of goods to him. S pays T the money, with which T runs away. In the light of the above facts, which of the following statement is correct? Option 1, H payment is not good as against R. Option 2, H payment is good as against R. Option 3, R can recover payments jointly and severally from S and T. And option 4, none of the above. In question number 71, the correct answer is option 2. As payment is good as against R. Now let us see the question number 72. A entered into a contract to purchase tomatoes from B, which were to be sourced by B from a farm of C. However, due to heavy floods, there was no crop of tomatoes on the farm of C. Here, the options are: A may sue B for damages, A or B may treat that agreement is void, neither A nor B is at fault, A may sue B for delivery, only B can treat the agreement as void. From the above statement of question, it is correct. The correct answer will be second answer, because it will not be possible for them to perform the contract, so it becomes a void. A or B may treat the agreement as void, as neither A or B is at fault. Which of the following statement is incorrect? In this question, an incorrect statement is asked. Stipulation as to time of payment is not deemed to be the essence of the contract of sale under Sales of Goods Act 1930 unless otherwise specified. Option 2, the warranty is a stipulation collateral to the main purpose. Option 3, warranty is accompanied with the right to reject the goods but without right to claim damages. In this question, the correct answer is only third. Warranty is accompanied with the right to reject the goods but without right to claim damages, because in this question is incorrect statement is asked, so this is the incorrect statement. Other statements are correct statement of statement first and second. Now let us see the question number 74. A agrees to supply B sunflowers for extraction of oil at a future date at a price not fixed as per the current market. Can he do so? Options are: yes, section 6 recognizes the agreement affecting the present sale of future goods. No, agreement is void under section 30 of the Indian Contract Act 1872 as it is a wagering contract. Option 3, no, as the price is not fixed under section 9 of the Sale of Goods Act 1930. Option 4, since there are no goods, the contract is voidable under section 17 Sales of Goods Act 1930. The correct answer for this question is yes, section 6 recognizes the agreement affecting the present sale of future goods. Section 6 of the Sales of Goods Act 1930 talks about the existing or future good. Section 6 clause 1, the goods which from the subject of a contract of sale may be either existing goods owned or possessed by the seller or future goods. So the correct answer is option 1. Now let us see the question number 75. An exporter in India X entered into an agreement with an importer in Germany Y and agreed to deliver 500 tons of basmati rice. The delivery was to be at the Hamburg airport in Germany, though Z shipping company with the first port of a call being port at Genoa. The shipment has to be delivered within 40 days of the opening of the letters of credit. The seller shipped the goods 16 days later than the stipulated time. Hence, he could not ship the merchandise through Z shipping company. He loaded the same on the ship of ZL company, which was not passing by the designated port of Genoa. On the way, the ship developed a snag. As a result, the ship was taken to Turkey, where the repairs were carried out, after which the goods reached the port at the Hamburg 40 days later. When the goods were to be taken on delivery, it was found that due to rise in humidity levels, the good had putrefied. In the light of these facts, which of the statement are correct? Statements are: the buyer will have to suffer the damages as the bill of lading have been handed over. Option 2, the seller have to take the risk and be liable for the pay damages as under section 26 until delivery. The risk remains to the seller. And option 3, the contract is voidable at the instance of the seller under section 7 as the goods has perished because of the ship and had developed a snag. The seller is not liable to pay damages. The buyer can claim insurance. In this question, the correct statement is statement 2, because here it is required to understand the section 26 of the Sales of Goods Act. Sales of Goods Act in section 26 talks about the risk prima facie passes with the property. It says that unless otherwise agreed, the goods remain at the seller's risk. The goods remains at the seller risk until the property therein is transferred to the buyer. But when the property therein is transferred to the buyer, the goods are at the buyer's risk, whether delivery has been made or not. So here the delivery has not been made, so it is at the risk of the seller to with related to section 26. So this is the correct answer. Question number 76. While sentencing the accused in an offence under Prevention of Corruption Act 1988, the relevant criteria is reformation, deterrence and denunciation, both 1 and 2, and none of the above. Question number 76, the correct answer is option 2, deterrence and denunciation. Now let us see the question number 77. A special judge is trying a case for the offence of Prevention of Corruption Act 1988 as well as Non-Prevention of Corruption Act 1988. The sole public servant dies after a special judge has exercised his power under Section 4, Clause 3 of the Prevention of Corruption Act 1988. The options are: the proceeding before the special judge vitiate, the special judge is divested of his power, the proceeding before the special judge which continue, and option 4, both 1 and 2. Here the correct answer is the proceeding before the special judge will continue. Now let us see the question number 78. Previous sanctions is necessary for taking cognizance of the offences punishable under which of the following sections of the Prevention of Corruption Act 1988. Options are Section 7 and 11, Section 13 and 15, Section 8 and 9, and both 1 and 2. Here the correct answer is both 1 and 2, that is Section 7 and 11 and Section 13 and 15. That means Section 7 and 11 and also Section 13 and 15. Section 11, 13 and 15 comes under the Chapter 3rd of the Prevention of Corruption Act 1988, and these are related to offences and penalties. Now let us see the question number 79. Presumption under Section 20 of the Prevention of Corruption Act 1988 is applicable for offences punishable under which of the following sections of the Act? Options are Section 7 or 11, Option 2, Section 7, 11 or 13, Option 3, Section 7, 8, 11 or 13, and Option 4, all the offences under the Prevention of Corruption Act 1988. Here the correct answer is Option 1, Section 7 or 11. Section 20 talks about the presumption where public servant accepts gratification other than legal remuneration. Which of the following is a public servant within the meaning of the Prevention of Corruption Act 1988? Option 1, chairman of a private bank receiving financial aid from central government. Option 2, arbitrator appointed by a public authority. Question 3, a commissioner appointed by courts. And option 4, all of the above. In this question, all of them are the public servant with relation to the Prevention of Corruption Act 1988. In IPC Section 21, public servant is defined. Now let us see the question number 81. Which of the following sections under the Protection of Children from Sexual Offences Act 2012 POSCO provides that if an act of the offender constitutes an offence of rape under IPC as well as under the Protection of Children from Sexual Offences Act 2002, then he is liable for punishment in either the Protection of Children from Sexual Offences Act 2012 or IPC, whichever is higher. The options are Section 42A, Section 10, Section 8 or Section 42. Here the correct answer is Section 42. POSCO Act 2012, Section 42 talks about the alternate punishment. Presumption of culpable mental state on the part of the accused is provided under which of the following offences of Protection of Children from Sexual Offences Act 2012? Option 1, offences punishable under Section 4 and 6 only. Option 2, offences punishable under Section 14 and 15 only. And Option 3, offences punishable under Section 8 and 10 only. Or all of the above. In this question, the correct answer is all of the above. Section 4 talks about penetrative sexual assault, and Section 6 talks about the punishment for aggravated penetrative sexual assault, whereas Section 8 talk about the punishment for sexual assault, and Section 10 talks about the punishment for aggravated sexual assault. And here similarly Section 14 and 15. Section 14 talks about punishment for using child for pornographic purposes, and Section 15 talks about punishment for storage of pornographic materials involving child. Here the option 4 is the correct options, all of the above. Question number 83. A makes a child aged 10 years to touch the penis of other person. Option 1, A is guilty of only sexual assault. Option 2, A is guilty of only penetrative sexual assault. Option 3, A is guilty of aggravated sexual assault. And option 4, all of the above. Here the correct answer is option 3, A is guilty of aggravated sexual assault, and aggravated sexual assault is given under Section 7. Now let us see the question number 84. While recording the statement of a child under Section 164 of CRPC with regard to an offence under Protection of Children from Sexual Offences Act 2012. Option 1, the presence of the advocate of the accused is mandatory. The presence of the investigation officer is mandatory. The presence of a parent of a child or such other person whom the child trusts is mandatory. 4, all of the above. Here the correct answer is option 3. The presence of the parent of the child or such officer in whom the child has trust is mandatory. Question number 85. Non-explanation of injuries on the person of the accused by the prosecution witness. Option 1 is always fatal to the prosecution case, is never fatal to the prosecution, may affect the prosecution case, provided serious injuries are suffered in the same occurrences, and option 4, none of the above. Here the correct answer is option 3, may affect the prosecution case provided some injuries are suffered in same occurrences. 86. For an offence punishable under Section 498A of IPC. Option 1, court where the offence was partially committed will have jurisdiction. Court where the matrimonial home is situated will have jurisdiction. Court where wife has taken shelter will also have jurisdiction. And option 4, all of the above. Here the correct answer is all of the above. Section 498A of IPC talks about whoever being a husband or the relative of the husband of a woman subjects such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine. So this section 498 talks about the cruelty. Section 303 of Indian Penal Code was struck down by the Supreme Court in which of the following judgments? Options are Gayatri versus State of UP, option 2 Mithu versus State of Punjab, option D Virsa Singh versus State of Punjab, and Raghunath versus State of Haryana. Here the correct answer is Mithu versus State of Punjab. By this case, the section 303 of IPC was struck down by the Supreme Court. Section 303 of IPC talks about the punishment for murder by life convict. Question number 88. A is married and is having one child. A is husband and B does not live with her. C on false promise to marry A makes physical relationship with her and later refused to marry. Options are C has committed the offence of rape. Option second, C has not committed the offence of rape. C has committed the offence of sexual assault. Option 4, C has committed the offence under section 494 of IPC. Here the correct answer is option second, C has not committed the offence of rape. Question number 89. Any omission or error in framing of charge, either stating the offence or particulars required to be stated therein, is fatal to be trial, is always material, is material only if occasions and failures of justice cannot be altered during the trial. Here the correct answer is material only if occasions in failure of justice. Now let us see the question number 90. The Government of India in 1992 has acceded the Convention on the Rights of the Child was adopted by the option 1 Parliament, option 2 European Council, option 3 General Assembly of United Nations, and option 4 Security Council of United Nations. Here the correct answer is option 3 General Assembly of United Nations. This convention of 1992 was signed in 1992, and in later 2012 POSCO Act was created related to this convention. On 14 November 2012 POSCO Act enforced. Now let us see the question number 91. A child in need of care and protection within the meaning of Juvenile Justice Care and Protection of Children Act 2015 means a child who is found begging, who is found working in a contravention of labor laws for the time being in force, who is without any home. Option 4, all of the above. In this question, all the options which are given are correct because the option 4 which says all of the above is the right answer. Now let us see the question number 92. Which one of the following statement is correct? Undue advantage under section 2D of the Prevention of Corruption Act 1988 is legal remuneration only. Gratification under the Prevention of Corruption Act 1988 means pecuniary remuneration only. Option 3, legal remuneration is restricted only to remuneration paid to the public servant, and option 4, none of the above. In this question, the correct statement is asked. None of the statements given are the correct answer, so the option is option 4, none of the above. Now let us see the question number 93. Sanction under the section 19 of the Prevention of Corruption Act 1988 is a mere formality to protect a public servant against malified prosecution. Option 3, exactly similar to section 197 of the Code of Criminal Procedure 1973. Option 4, only required if public servant has retired. In question number 93, the correct answer is option 2, to protect a public servant against malified prosecution. Now let us see the question number 94. A public servant has a property disproportionate to his known source of income within the meaning of the Prevention of Corruption Act 1988 when he has more amount lying in his bank account than his monthly salary, has more than 5 immovable properties, fails to satisfactorily account for property, has more than 10 vehicles. In question number 94, the correct answer is option 3, fails to satisfactorily account for the property. Now let us see the question number 95. Gratification within the meaning of the Prevention of Corruption Act 1988 means pecuniary gratification, anything estimable in money, acceptance of anything to the pleasure or satisfaction of the recipient, and option 4, all of the above. All of the above statements are correct because all the three statements defines what gratification actually is. So all of the statements are correct. Now let us see the question number 96. Commercial organization under section 9 of the Prevention of Corruption Act 1988 does not include domestic companies, foreign companies, charitable or business organizations, subsidiary companies. Does not include section 9 of the Prevention of Corruption Act. The correct answer is 3, charitable or non-business organization. This is the correct answer because this asks which commercial organization does not include what. So commercial organization does not include charitable or non-business organization. And what does it include? This includes domestic companies, foreign companies, and subsidiary companies. Now let us see the question number 97. The Protection of Children from Sexual Offences Act 2012 was amended. Derives power from which of the provisions of the Constitution? The correct answer is Article 15 Clause 3, which state can make law for the protection of the children. I have made the entire video of POSCO Act. In the playlist you can find this, in which I have thoroughly discussed each and every section of the POSCO Act. Now let us see the question number 98. The Protection of Children from Sexual Offences Act 2012 is applicable when the victim is a child below the age of, options are 18 years, option 2 19 years, and option 3 21 years, and option 4 none of the above. POSCO Act applies to child irrespective of whether a boy or a girl below the 18 years of age. So this 18 years age option 1 is the correct answer. Question number 99. The Protection of Children from Sexual Offences Act 2002 provides protection from sexual abuse. I have already discussed this in question number 98. It is a gender neutral. POSCO Act is a gender neutral, so the option 3 will be the correct answer. It applies to both boys and a girl for the protection of sexual abuse. Now let us see the question number 100. Punishment for commission of offence of sexual assault, section 8 of the Protection of Children from Sexual Offences Act 2012 is not less than. Options are 3 years but may be extended to 5 years. Option 2 5 years but may be extended to 7 years and fine. And option 3 7 years but may extend to 10 years and fine. And option 4 10 years but may extend to 12 years and fine. Here the correct answer is option 1 3 years but may extend to 5 years and fine in section 8 of POSCO Act. The child-friendly procedure under the POSCO Act 2012 is applicable only during investigation of an offence under the Act, only during recording of evidence for an offence under the Act, only during inquiring into an offence under the Act, and all of the above. The child-friendly behavior has to be applied everywhere during the investigation, recording of evidence, and also in inquiring. So the option 4 is the correct answer. Now let us see the question number 102. If the management or employer, after retrenching a daily wager, regularizes another serving daily wager, the employer's action would be violative of which of the following provisions? Options are section 2E of the Industrial Disputes Act 1947, section 25F of the Industrial Disputes Act 1947, option 3 section 25H of the Industrial Dispute Act 1947, and option 4 none of the above. Here the answer is none of the above. All the sections which are given are not correct. So the answer is none of the above. Under the Payment of Wages Act 1936, in a factory or establishment wherein more than 1000 employees are working, the monthly wages must be released on or before the 5th day of the next month, option 2 the 7th day of the next month, option 3 the 10th day of the next month, and option 4 the 15th day of the next month. Here the correct answer is option 3 the 10th day of the next month. Question number 104. A claim by an employee under the Payment of Wages Act 1936 has to be preferred within which of the following periods from the date it is due or from the date on which any unauthorized deduction has been made. Options are 3 months, option 2 6 months, and option 3 1 year, and option 4 3 years. Correct answer is option number 3, that is 1 year. Now let us see the question number 105. Under the Minimum Wages Act 1948, the maximum compensation which the competent authority is empowered to grant to an employee while allowing his claim arising out of payment of less than the minimum rate of wages is, option is double the differential amount, option 2 4 times the differential amount, option 3 10 times the differential amount, and option 4 equivalent to the differential amount. In this question, correct answer is option 3 10 times the differential amount. Let us see the question number 106. A person aggrieved by an order passed by the Commissioner under the Employees Compensation Act 1923 awarding a lump sum compensation, interest or penalty can avail which of the following remedies? Options are raise an industrial dispute before the Labour Court, option 2 appeal before High Court, option 3 appeal before District Court, and option 4 appeal before the Central Government. In this question, the correct answer is option 2 appeal before the High Court. Question number 107. The employer is liable to pay compensation to employee under section 3 of the Employees Compensation Act 1923 if a personal injury sustained by the employee during the course of his employment results in this total or partial disablement exceeding options 2 days, 3 days, 1 week, 10 days. Correct answer is 3 days. Question number 108. As per the Factories Act 1948, an employer must provide a canteen for the use of its employees if the number of the workmen employed in the factory is more than 250. Correct answer is 250. Now question number 109. As per the Factories Act 1948, every adult who has worked for a period of 240 days or more in a factory during a calendar year is entitled to leave with wages for the following number of days in the subsequent calendar year. That is, options are 1 day for every 20 days of work performed during the previous calendar year, Option second, 1 day for every 15 days of work performed during the previous calendar year. Option third, 1 day of every 30 days of work performed during the previous calendar year. And option 4, 1 day of every 90 days of work performed during the previous calendar year. In this question, the correct answer is option number 1, that is 1 day for every 20 days of work performed during the previous calendar year as per the Factories Act 1948. Now let us see the question number 110. As per the Factories Act 1948, in every factory, a crèche by way of a suitable rooms for children under the age of 6 must be provided in case number of women employed is more than, answer is 30. Third option is the right answer. If there are 30 women working, then the facility of crèche should be provided as per the Factories Act 1948. Children below the age of 6 years. Now let us see the question number 111. The maximum number of weekly hours for which an adult worker can be required to work in a factory as per the Factories Act 1948 is 48 hours, 50 hours, 52 hours, 54 hours. Maximum number of weekly hours, correct answer is option 1, 48 hours. Now let us see the question number 112. The PF account, Provident Fund amount which an employee can withdraw within 1 year of his retirement in accordance with the provisions of Employees Provident Fund and Miscellaneous Provision Act 1952, provided he has attained the age of 54 year. Option 1 is 25% of the amount standing to his credit. Option 2, 50% of the amount standing to his credit. And option 3, 90% of the amount standing to his credit. And option 4, 100% of the amount standing to his credit. Here the correct answer is option 3, 90% of the amount standing to his credit. Now let us see the question number 113. Damages recoverable under section 14B of the Employees Provident Fund and Miscellaneous Provision Act 1952 from an employer for default in payment of the contribution in the fund can be up to option R, 25% of the amount of arrears, option second 10% of the amount of arrears, and option 3 50% of the amount of arrears, and option 4 100% of the amount of arrears. Here the correct answer is option 4, 100% of the amount of the arrears. Now let us see the question number 114. Option 1 is his amount of theft at his house was quite dash. Option second, do not be so dash that you believe in everything your leader says. Option 3, although a novice, his performance in debate was quite dash. And the 3 sentences above can be filled most appropriately in the correct order as. The options are, we have to find with the correct order which can be filled in these blanks. Here the correct answer is option 3, because the meaning of credible in Hindi is Vishwasniya, and credulous, the meaning of credulous is trustful. Creditable means prashanshaniya, someone to be praiseworthy. Question number 115. If the evidence dash, the charge will be indicated. The above blank can be filled in the most appropriately with the phrase. Option 1, bears up, bears out, bears with, bears away. Okay, here the correct answer is option second, bears out. If the evidence bears out, the charge will be indicated. Now let us see the question number 117. Such sort of slavish discipline makes a slavish temper. The child submits and dissembles obedience, whilst the fear of the road hangs over him. But when that is removed, and by being out of sight, he can promise himself impunity, he gives the greater scope to his natural inclination, which by this way is not at all altered, but on the contrary heightened and increased in him, and after such restraint breaks out usually with more violence. John Locke. Which of the following best expresses the essence of the above passage? Here in this question we have read the passage which was written by John Locke. We have to give the correct answer which is related to this passage. So the options are: spare the rod and spoil the child, children dissemble obedience but naturally given to disobedience, children have to be restrained otherwise they become violent, excessive discipline is harmful for children and makes them even more indisciplined. This is more appropriate relating to the passage we have read, option 4. Correct answer is option 4, 118. The word pulchritude means beauty, oddness, complexity, stubbornness. Here the correct answer is beauty. Which Constitutional Amendment Act relates to the introduction of GST? This is a very important question asked in various examination. Correct answer is Constitution 101st Amendment Act. Now let's see the question number 120. Which article of the Constitution of India incorporates the doctrine of pleasure in connection with the tenure of office of a member of the civil services of the Union or state or a person holding civil post under the Union of a state? Options are Article 310, Article 312, Article 320 and Article 323A. Here the correct answer is Article 310. Article 310 is the correct answer, and Article 310 of the Constitution of India incorporates doctrine of pleasure by clearly stating that every person who is a member of a defense service or of a civil service or of the union of an all Indian service or holds any post connected with the defense or any civil post under the union holds the office during the pleasure of the president. Now let us see the question number 121. The judgment of the Supreme Court of India in the matter of Minerva Mills Limited versus Union of India reported in 1980 pertains to option 1, constitutionality of the provisions of the Constitution 25th Amendment Act, option 2, constitutionality of the provisions of the Constitution 39th Amendment Act, and option 3, constitutionality of the provisions of the Constitution 42nd Amendment Act, and option 4, constitutionality of the provisions of the 44th Amendment Act. In this question, the correct answer is option 3, constitutionality of the provisions of the 42nd Amendment Act. Now let us see the question number 122. First woman chief minister was from which of the following Indian states? Option are West Bengal, Uttar Pradesh, Tamil Nadu and Kerala. Here the correct answer is option number 2, Uttar Pradesh. First woman chief minister was Suchita Kripalani. She was the first chief minister of Uttar Pradesh, and her tenure was from 1963 to 1967 in UP. Okay, and one more thing I want to add, first woman governor, and that will be Sarojini Naidu. Now let us see the question number 123. The best motion picture award for the Oscar 2019 was awarded to. This was the question related to current affairs. Here the answer is Green Book, but if in case there is the question again came of similar pattern and was asked who was the given best motion picture award for 2021, then the correct answer will be Nomadland. Okay, now let's see the question number 124. The current president of the World Bank Group is. Options are David R. Malpass, Antonio Guterres, Tom Wilkinson and Mikhail Mishustin. Correct answer is David R. Malpass. This is the correct answer, and he is the president of the World Bank Group. Now let us see the question number 125. Again, this question is related to current affairs. The Royal Swedish Academy of Sciences awarded the Severance Risbank Prize, the Economic Sciences, in the memory of Alfred Nobel Prize 2019. Basically, they are asking the Nobel Prize winner in economics for 2019. For 2019, the correct answer, as we all know, because one Indian, Abhijit Banerjee, and his wife, Athlete Deflo, was the co-winner in economics. So this is a very important question we all must know. And with him, Mikhail Kremer was also there in economics Nobel Prize. So this is the correct answer. But in case if 2021 economics prize is asked, then you have to know the three names of the Nobel laureates, that is David Card, Joshua Angrist and Guido Imbens. These three persons have got the Nobel Prize in Economics in 2021. Now let us see the question number 126. Limitation period for drawing up of a final decree for partition from the preliminary decree for partition is. Options are 6 months, 12 years, 3 years and none of the above. In this question, the correct answer is none of the above. Now let us see the question number 127. The limitation period to set aside an ex parte decree from the date of the decree where the summons or notice was not duly served from the date when the applicant had knowledge of the decree is. Option 1, 90 days, option 3, 30 days, option 3, 3 years and option 4, 6 days. In this question, the correct answer is 30 days. Now let us see the question number 128. A was allotted a plot of land by the Union of India. The allotment was cancelled and the said cancellation was upheld in a writ petition till the Supreme Court. A was however given liberty to file a civil suit and seek compensation. A files a suit for the compensation. In the suit, options are the findings of the final judgment in the writ petition would not operate as res judicata. The findings in the final judgment in the writ petition would operate as res judicata. And option 3, the findings of the final judgment in the writ petition would operate as res judicata, the issue decided. And option 4, the findings in the final judgment in writ petition would operate as res judicata qua all issues. Here the correct answer is option 3, because the findings in the final judgment, according to this question, in the writ petition would operate as res judicata, the issue decided. You have to know about the doctrine of res judicata. The doctrine of res judicata operates as a bar on the jurisdiction of a court to try a suit which has been conclusively decided by the court with the same party, same subject matter under the same title. And it has been given in section 11 of the CPC. Correct answer is option 3. Now let us see the question number 129. A suit for the declaration and injunction is filed between family members. The defendants make a counterclaim. The parties are referred to mediation and a settlement is entered into between the parties. The plaintiffs has paid the court fees on the suit. The defendants has also paid the court fees on their counterclaim. In view of the settlement, options are only the plaintiffs are entitled to refund of court fees, only the defendants are entitled to refund of the court fees. Option 3, both parties are entitled to refund of 50% of the court fees paid, and option 3, both parties are entitled to complete refund of the court fees. Here the correct answer is option 4, both parties are entitled to complete refund of court fees. Now let us see the question number 130. The court is entitled to give a summary judgment on a claim in a commercial dispute. Options are only in favor of the plaintiff if the defendant has no real prospect successfully defending the claim, only in favor of the defendant if the plaintiff has no real prospect of succeeding in the claim and there is no other compelling reasons why the claim should not be disposed before recording oral evidence, and option 3, in favor of the plaintiff defendant as the case may be if the plaintiff has no real prospect of succeeding on the claim or the defendant has no real prospect of successfully defending the claim, and option 4, against the plaintiff or defendant if the plaintiff has no real prospect of succeeding on the claim or the defendant has no real prospect of successfully defending the claim as the case may be, and there is no other compelling reason why the claim should not be disposed of before the recording of oral evidence. In this question, the correct answer is option number 4, against a plaintiff or defendant if the plaintiff has no real prospect of succeeding on the claim or the defendant has no real prospect of successfully defending the claim as the case may be, there is no other compelling reason why the claim should not be disposed of before recording the oral evidence. Now let us see the question number 131. Company A is the registered trademark holder of the mark White, VITE specifically. In respect of pens, Company B adopts the name White, VITE in respect of the ink. The adoption by Company B constitutes infringement, passing off, both infringement and passing off, neither infringement nor passing off. In this question, the correct answer is option 3, both infringement and passing off. Now let us see the question number 132. XLLC, an American company, is the owner of a registered trademark and carries on business across the world. It conducts business in India through its franchisees including Delhi and Mumbai. B, a Mumbai-based party using an identical trademark issues an advertisement in Delhi, seeking application for appointing franchisees in Delhi. XLLC files a suit for permanent injunction to restrain B from infringing the trademark before the court in Delhi. B raises an objection as to the territorial jurisdiction. Options are, the suit would not be maintainable as B is based in Mumbai. Option second, the suit would be maintainable under section 134 of the Trademarks Act. And option 3, the suit would be maintainable both under section 20 CPC and section 134 of the Trademarks Act 1999. Suit would be maintainable only section under 20 CPC. In this question, the correct answer is option number 4. Suit would be maintainable under section 20 CPC. Section 20 CPC talks about other suits to be instituted where defendants reside or cause of action arises. So here the correct answer is option 4. Now let us see the question number 133. Under trademark law, the rights of the prior user are superior than that of the registered proprietor of the mark. Options are true, option second false, third it is contingent upon the prior user proving registration, and option 4, the registered proprietor can interfere with the rights of the prior user. Correct answer is option 1, true. Under the trademark law, the rights of the prior user are superior than that of the registered proprietor of the mark. This is the correct statement. Now let us see the question number 134. An architect of a building which is intended to be demolished institutes a suit for permanent injunction averring that his copyright in the architectural drawings and designs will be affected by the demolition of the building. Options are, the architect has no right to seek injunction against the demolition. The architect has rights under the Copyright Act 1957 and can seek an injunction. The architect has rights under Copyright Act 1957 and can seek injunction only if the building is situated in a city declared by UNESCO as a heritage city. And option 4, the architect can obtain injunction but only if the owner to whom he has sold the architectural drawings and design of the building is made party to the suits and the consents of the injunction. In this question, the correct answer is option 1. The architect has no rights to seek injunction against the demolition. Now let us see the question number 135. Industrial drawings were used in the production of more than 50 devices by an industrial process. The plaintiff, who is the owner of copyright of these industrial drawings, does not have a design registration. It shall, options are, have rights under the Copyright Act 1957, not have rights under the Copyright Act 1957, have rights under the Design Act 2000 along with the Copyright Act 1957, and option 4, have rights only under the Design Act 2000. Here, the correct answer is option second, does not have rights under the Copyright Act 1957. Now let us see the question number 136. Under the Commercial Codes Act 2015, options, time period for filing the written statement is 90 days and is not extendable for any reason whatsoever. Time limit of 120 days for filing the written statement is extendable as per Kailash versus Nanku. The time limit of 120 days for filing the written statement is not extendable. There is no limitation for filing the written statement. In the given options, the correct answer is option number 3rd. The time limit of 120 days for filing the written statement is not extendable. This is the correct answer. Now let us see the question number 137. An order which refers parties to arbitration under Section 8 of the Arbitration and Conciliation Act 1996 is, options are appealable under Section 13 Clause 1 of the Commercial Codes Act 2015, not appealable under Section 13 Clause 1 of the Commercial Code Act 2015, appealable under Section 37 Clause 1 Clause A of the Arbitration and Conciliation Act 1996, appealable under Section 96 of CPC. In the given option, option number 2nd is the correct answer, not appealable under Section 13 Clause 1 of the Commercial Codes Act 2015. This is the correct answer. Section 13 of the Commercial Codes Act talks about the appeals from decrees of commercial courts and commercial divisions. Now let us see the question number 138. A boy posts some ex facie defamatory comments about his friend on Facebook. The friend is offended by the content and files a suit for defamation seeking injunction for removal of the content and damages. Facebook Inclusive is also pleaded as defendant. If the contention of Facebook Inclusive that is not liable for any damages and shall comply with any direction of the court. Options are, there is merit in contention of Facebook in view of the Section 79 of the Information Technology Act 2000. There is no merit in the contention of Facebook and it having provided its platform for the content to be published is liable for, like a newspaper, for the defamation affected through its medium. Option 3, there is merit in contention of the Facebook in view of the Section 66E of the Information Technology Act 2000. There is no merit in contention of the Facebook in view of its express liability under Section 79 of the Information Technology Act 2000. In this question, the correct answer is option 1. There is merit in contention of Facebook in view of the Section 79 of the Information Technology Act. Now let us see the question number 139. The Supreme Court has struck down which of the following sections of the Information Technology Act 2000? This is the very important question and this has been asked in various examinations. The correct answer is Section 66A, and Supreme Court has struck down this section of Information Technology Act in Shreya Singhal versus Union of India. Now let us see the question number 140. A certificate under Section 65B of the Indian Evidence Act 1872, which was inserted by the Information Technology Act 2000, must contain the following. Options are identification of the electronic record containing the statement sought to be given in evidence, describe the manner in which electronic record was produced, signatures of a person occupying a responsible official position in relation to the operation of the relevant device or the management of the relevant activities, and option 4, all of the above. In relation to Section 65B, all of the options are the correct answers. So let us see the question number 141. Which of the following statement is not true in relation to the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002? Options are, it was introduced in order to expedite the enforcement of security interests and to provide a central database of security interests created on property rights. Option 2, it was preceded by an ordinance promulgated by the President in 2002. And option 3, it had been amended 4 times since it came into force. And option 4, it applies to all loans without monetary limits and also to security interest on the agricultural land. Correct answer is option 4. Option 4, it applies to all loans without monetary limits and also to security interest in agricultural land. This is the correct answer. Now let us see the question number 142. A, who is a wholesale dealer of hosiery at Gandhinagar, Delhi, purchases goods worth 10 lakhs from B, who is a manufacturer of hosiery clothes at Tirupur, Tamil Nadu. A issues 4 checks of 2.5 lakhs each, drawn on a nationalized bank. B deposit the first check at the branch of X, his bank at Tirupur, which is also nationalized bank and with whom he is maintaining his account. It is honored. While on a business trip to Coimbatore, Tamil Nadu, B deposits the second check at the branch of his bank at Coimbatore, where to he maintains an account. The Coimbatore branch of his bank sends him a written memo informing that check has check has been returned due to insufficient funds. B files a complaint under section 138 at Coimbatore. He presented the third check, Tirupur, which was also dishonored. Where can B file the second complaint under section 138 of the Negotiable Instrument Act 1881? Total 3 check issued. First was in Tirupur, second was in Coimbatore, and the third was in Tirupur again. In Tirupur, check was cleared. In Coimbatore, check wasn't clear, it was dishonored. And again the third check in Tirupur was dishonored. So we have to find the correct answer in the given options. Now the question, option 1 is, option 1, the second complaint will have to be filed only in the same court even if it does not have territorial jurisdiction. Option 2, he can file the complaints only at Delhi. This is the wrong answer because Delhi was not in the picture. Coimbatore and Tirupur was in the picture. He can file one complaint before the competent court at Coimbatore in respect of the check dishonored on the presentation there, and the other complaint at Tirupur in respect with the check dishonored the presentation at Tirupur. This is not the right answer. He can file complaints as per his convenience before the competent court at Delhi, Coimbatore or Tirupur. Again, Delhi is given here, otherwise this could have been the right answer, but option 1 in the given option is the correct answer. The second complaint will have to be filed only in the same court even if it does not have territorial jurisdiction. Now let us see the question number 143. Which of the following statement is incorrect? The prosecution against director is maintainable even when prosecution against the company is dropped because of the winding of proceeding against the company. Option 2, no director can be prosecuted under section 141 of the Negotiable Instrument Act 1881 unless it is averred in the complaint that he was directly or indirectly in charge of and responsible for the affairs of business of the company at the time when the check was issued. Now, option 3, the issuance of the check is presumed to be towards legal liability. Stop payments instructions are not considered as dishonor of a check. In the given question, in the given options, it has been asked to find the incorrect answer. The incorrect answer for this question is option number 4. Stop payment instructions are not considered as dishonor of check. This is the incorrect statement. Therefore, is the right statement in the given question. Now let us see the question number 144. In a recent decision of the Supreme Court reported as Bajrang Shyam Sundar Agarwal versus Central Bank of India 2019 SEC, while dealing with the rights of tenant vis-a-vis the rights of a secured debtor under the Securitization and Reconstruction of Financial Assets Enforcement of Security Interest Act 2000 SURFACE Act, which of the following propositions was not laid down? Options are, if a valid tenancy under law is in existence even prior to the creation of a mortgage, the tenant's possession cannot be disturbed by the secured creditor by taking possession of the property. The lease has to be determined in accordance with the section 111 of the Transfer Property Act 1881. The rights of the rightful tenant cannot be compromised under the SURFACE Act proceedings. Option 2, if a tenancy under the law comes into existence after the creation of a mortgage but prior to the issuance of notice under section 13 clause 2 of SURFACE Act, it has to satisfy the condition of section 65A of the TPA. Option 3, in any case, if any of the tenants claims that he is entitled to possession of a secured asset for a term of more than 1 year, it has to be supported by the execution of registered instrument. If the tenant relies on an unregistered instrument or an oral agreement accompanied by the delivery of possession, the tenant is not entitled to the possession of the secured assets for the more than the period prescribed under section 107 of the Transfer Property Act 1881. And option 4, the rent control legislation, if any, restricting eviction of tenants save on the grounds provided therein, if applicable to the tenancy, prevails over the provisions of the SURFACE Act. In this question, the correct answer is option number 4. This is the right answer. Now let us see the question number 145. What is the effect of filing of a winding up petition by a secured creditor before the company court after issuance of the recovery certificate under the Recovery of Debts Due to Banks and Financial Institution Act 1993 as per the decision of the Supreme Court in Swaraj Infrastructure Private Limited versus Kotak Mahindra Bank Limited 2019? Options are, subsequent winding up proceedings will be barred, stay of winding up proceedings. Option 3, stay of proceedings under the Recovery of Debts Due to Banks and Financial Institutions Act 1993. Both may be prescribed in parallel. In this question, the correct answer is option 4, both may be proceeded in parallel. Now let us see the question number 146. After the decree of recovery of debt due to the bank is made by way of issuance of recovery certificate by presiding officer of the DRT, the recovery officer can, option 1, attach and sell the movable and immovable property of the defendant. Option B, arrest the defendant and detain him in prison. And option 3, appoint a receiver for the management of a movable and immovable properties of the defendant. In this question, all the statements which are given are the correct statements. So in the given options, option 4 will be the right answer because all the statements are the right statement. Now let us see the question number 147. Which of the following statements are true to ascertain whether a document creates a license or a lease? If a document creates an interest in the property, it is a lease. However, if it only permits another to make use of property of which legal possession continues with the owner, it is a license. Option second, the real test is the intention of the parties, whether they are intended to create a lease or a license. Option 3, the substance of a document must be preferred to the form of the document. And option 4, if the party gets exclusive possession under the document, he is prima facie a tenant, but circumstances may be established which negate the intention to create a lease. Now let us see the options. Options are only first and third are correct, only first and second are correct, and only third and fourth are correct, and option 4, all are correct. In the given question, all the options are the correct options. Now let us see the question number 148. Under which provisions of the SRA specific performance of a contract may be enforced when the promoters of a company have before its incorporation entered into a contract for the purpose of the company, and such contract warranted by the terms of incorporation is accepted by the company and communicated to the other party under Section 20A, Section 19, Section 17 or Section 20. In the given question, correct answer is option number second, that is Section 19. Let us see the question number 149. Which of the following statement is not true? Here we have to find which is not true. The options are: in a suit filed for a specific performance of contract for the transfer of immovable property, no relief for refund of earnest money can be granted by the court unless specifically claimed. Option second, the dismissal of a suit for a specific performance of a contract or a part thereof shall bar the plaintiff's right to sue for compensation for breach of such contract or part, and shall also bar his right to sue all other reliefs by reason of such breach. And option 3, a court may refuse to rescind the contract where the plaintiff has expressly or impliedly ratified the contract. And option 4, no relief for rectification of an instrument shall be granted to any party under the Section 26 unless it is specifically claimed. In question number 49, correct answer will be question number 2 because this is not the true statement in the given options. Statement 1, 3rd and 4th are the right statement, and the question is asked which is not true. This is not true, so the option second will be the right answer. Now let us see the last question, question number 150. Which of the following court cannot grant in its discretion under the Specific Relief Act 1963? Declaration, simpliciter, mandatory injunction, damages in lieu of injunction, an injunction to prevent the breach of a contract, the performance of which would not be specifically enforced. Question is, which of the following the court cannot grant in its discretion under the SRA? Correct answer is 4. In SRA, an injunction to prevent the breach of a contract, the performance of which would not be specifically enforced, will not be granted. So this is the correct answer. Here we will wind up this video. In another video of this playlist, we will discuss the next question paper of Delhi HJS. Thank you for watching. Please like, share and subscribe. And one more thing, we have made a new Telegram channel. Channel will be a discussion forum. Please like, share and subscribe and share with your friends. Thank you so much.